Good afternoon, everybody. What a gorgeous day it is outside.
Let's move the committee outside.
I was just going to suggest that. Could we do that outside? We wouldn't be able to hear anybody, but... Okay. All phones are off? All phones are off? Thank you. Welcome, everybody, to meeting 117 of the Standing Committee on Industry, Science and Technology as we continue our 5-year review of the legislative review of copyright. Today, we have with us from the Canadian Teachers Federation, Mr. Mark Ramsankar, President. From the Canadian School Boards Association, Cynthia Andrew, Policy Analyst. And from the University of Calgary, Drew Marshall, Provost and Vice President, who will save you for last. So we're going to actually start off with Mr. Ramsankar. You have up to 7 minutes. 7 minutes.
Thank you, Chair. My name is Mark Ramsankar. I'm the President of the Canadian Teachers Federation. But first and foremost, I'd like to suggest that I'm a school teacher. I've had the opportunity throughout my career to teach all grades, as well as work as a consultant with the school board in Edmonton. Been a special ed teacher as well as an administrator. So I'm speaking from the perspective of the entire education system, K to 12, over my 25 years in the classroom. As the national voice for Canadian teachers, I represent here today 250,000 teachers in the K to 12 system in every province and territory in the country. We have a part and a strong connection to Education International, which represents over 30 million teachers across the world. We have a long-standing member of the Education Coalition on national education organizations. We advocate for the rights of teachers and students in the federal government's copyright reform process. We've worked very closely with the Education Coalition partners to develop education materials for teachers on matters relating directly to copyright. We believe very firmly in protecting the legitimate interests of creators and publishers by ensuring there is no copyright infringement when teachers are copying materials for use in their classrooms and for students. We also believe that the current fair dealings provisions maintain a very strong balance between user rights and creator rights, and we view this as very strong public policy. Even our global organization, through the Education International, holds that the Canadian Copyright Act, as it stands, is held in very high regard. Teachers are professionals who respect copyright, and we also teach our students, when they do research, to respect copyright. Teachers will not copy materials if there is any doubt, and they do not copy whole textbooks. It infuriates us through the profession when somebody says something such as this, where we take a teacher who's blatantly stepping on copyright rules. Over the last decade, there's been a dramatic shift from print-based materials and resources like textbooks to digital resources. And today in our classrooms, as challenging as they are, teachers find effective ways to teach through these evolving technologies. They are creating their own resources and materials, and they're using collaborative approaches to content in creation and engaging students so that they can learn through online resources as well as more traditional print material. As professionals in the K-12 system, teachers want their students to have access to the very best educational content that is available. Speaking directly to copyright, it is an important issue, and it's a subject that has been raised by the Canadian Teachers Federation with teachers. We speak about compliance and take part in awareness of consequences to infringing on copyright. We also engage in a comprehensive awareness program in efforts to ensure that teachers are aware of copyright and the limits of the law when they are preparing for their classes. Teachers are professional. Anecdotal stories of whole textbooks being copied are isolated incidences. I speak directly for the K-12 system in education, and that is public education. I don't stand here to represent extended education or private. For CTF, it's not about the money, but from our view, it's about students and providing the best for their learning experience in our system and their futures. I stand and came today to witness and represent the Canadian teachers, and I'm urging the Standing Committee to maintain the current fair dealings provision, which balances the protection of both creators and users. I also ask you to consider your decisions and consider the fact that 250,000 teachers work with children every day in this country. The decisions that are made as we go forward in regard to copyright will have very damning effects on classrooms across the country, and every student in the K-12 system will be affected by the decisions that are made at the outcomes of these hearings. Thank you very much, Chair.
Thank you very much, and we're going to move right to Cynthia Andrew from Canadian School Boards Association. You have up to 7 minutes.
Thank you, Mr. Chair. Good afternoon, everyone. Again, my name is Cynthia Andrew, and I appear before you this afternoon representing the Canadian School Boards Association. The Canadian School Boards Association members are the provincial school board associations that represent just over 250 school boards across Canada, and they serve slightly less than 4 million students across Canada, elementary and secondary school students. I am an employee of one of those provincial associations, the Ontario Public School Boards Association, and I am the key staff person both in Ontario and within CSBA for school boards on all matters relating to copyright. And I am pleased to be able to appear before you this afternoon to speak about copyright and school boards. Copyright law affects all of Canada's school boards, and it is reflected in policies and practices in school board administration and in classrooms across the country. As a result, CSBA has been attentive and active in issues related to copyright reform since the 1990s. CSBA works closely with other national educational organizations on copyright-related policy development, and that is why you will notice that many of our supporting materials are the same as those materials you have already seen from other witnesses before you on this issue. For example, the Fair Dealing Guidelines and the Copyright Matters booklet. CSBA recognizes the importance of copyright awareness in the K-12 education community, and we do our part along with our provincial affiliates and our education partners to impart the need to foster greater understanding and compliance within our schools and within our classrooms. CSBA provides advice to local school boards through its provincial association members. The provincial ministries and departments of education can exercise greater authority, making certain policy requirements of school boards. I know you heard from them earlier this week through the CMEC Copyright Consortium. CSBA works cooperatively with the CMEC Copyright Consortium and with other national educational partners to ensure that consistent information about copyright, compliance, and copyright rights and responsibilities consistently is shared through our provincial school board associations with all of the school boards and their employees. This decision to educate school board employees consistently across Canada was made late in 2012 and was only partially a result of the amendments to the Copyright Act that passed earlier that year. The decision was also significantly a result of the 2012 Supreme Court decision that found it was fair for teachers to copy short excerpts of copyright-protected works for their students. It is that Supreme Court decision that prompted national education associations to establish the Fair Dealing Guidelines. CSBA supports the Fair Dealing Guidelines, supported the establishment of them, and worked with its provincial affiliates to ensure that directives from their respective provincial ministries were implemented effectively. CSBA believes that the Fair Dealing Guidelines provide school boards and their employees with clear copyright policy guidance, ensuring that educators are aware of their rights and their responsibilities under the Canadian copyright law. The Fair Dealing Guidelines ensures consistent application of the Supreme Court's decision, and its application is applied across the country. The guidelines are aligned with copyright law around the world so that our teachers and our students are on a level playing field with those from other countries. CSBA further believes that fair dealing for education purposes is good public policy that supports student learning and ensures effective use of taxpayer dollars. The Copyright Act balances rights between copyright owners and copyright users, and the fair dealing provision in the Act is an important right for Canadian educators. Fair dealing for the purpose of education allows teachers to access a wide range of diverse learning materials and thereby enriches students' learning experiences. The Supreme Court decision and the fair dealing guidelines have established a stability that CSBA supports and wishes to see maintained. Teachers are now certain when they're selecting materials for their lesson planning and when seeking those supplemental materials necessary for teaching individuals who may be more challenged with the lesson. CSBA is aware that publishers and Access Copyright have been vocal in their claims that fair dealing has caused them economic hardship. To date, they have not been able to present sufficient evidence that this is to support this claim beyond anecdotal examples. The other gap that is evident from the testimony to date is the degree to which the success or decline of publishers and Access Copyright reflect what is fair remuneration to creators. Will restoring tariffs and increasing tariff payments help those writers and those creators? CSBA does empathize with the challenges currently facing the education publishing industry. The industry is struggling to stay current with advancing technology and new perspectives about teaching and learning. Textbooks, once the primary learning resource available to educators, are now just one in a series of choices that school boards and teachers have available when preparing classes for their students. School boards spend their learning resource dollars on digital content repositories, on subscription-based databases, on online libraries, provincially developed or locally developed electronic resources, on apps, and of course in the internet. Again, the true value of the educational use of fair dealing is that educators now have the flexibility to adapt their materials to the specific needs of each class or even each individual student in ways that were unimaginable just a few years ago. While CSBA as an organization is not directly involved in any of the legal or quasi-legal actions that have occurred around copying in schools, some of our member school boards, those in Ontario, are directly involved. Other provinces' school boards are indirectly involved as their ministry is involved. So while CSBA itself might not be directly involved in these matters, we certainly have an ongoing interest in ensuring that the Copyright Act continues to balance the rights of both creators and the educational users. The fair dealing provisions in the Act provide balance in both rights and responsibilities. The Supreme Court and those other court proceedings that are playing themselves out today are providing the definitions and the clarity around fair dealing. There is a new normal in K-12 school community that educators are adapting to, that publishers are adapting to, and that teachers and students are benefiting from, that is about access to enriched learning material. CSBA asks MPs to not be tempted to apply legislative amendments to what is already a fair and balanced approach to copyright in our schools. Thank you.
Thank you very much. And finally, Ms. Marshall, you have up to 7 minutes.
Oh, good afternoon. I'm Drew Marshall, Provost and Vice President Academic at the University of Calgary and Chair of the Copyright Committee there. I want to begin by thanking members of the committee for their support for the post-secondary sector. Investments in our campus through the Post-Secondary Strategic Investment Fund and through the previous Knowledge Infrastructure Program have had a transformative effect on research and learning spaces on our campus. We also really appreciate the significant federal investments made in support of Canada's research ecosystem. I'm pleased to be able to be here today to make recommendations to the committee and to speak about the University of Calgary's approach to copyright. First, I want to emphasize that the University of Calgary supports the retention of fair dealing exception for education in Canada's copyright regime. As both creators and users of copyright material, universities must have a balanced approach to copyright and to the issue of fair dealing. Fair dealing helps ensure a high-quality educational environment for students and contributes to innovation in teaching by enabling an instructor to use a variety of examples in their lectures, exposing students to the most recent cutting-edge research. The speed at which textbooks and traditional print books are produced and distributed often does not allow for inclusion of these types of examples. At the University of Calgary, we take a measured approach to fair dealing, ensuring it is used to supplement or complement purchased material, not to replace it. We do not apply fair dealing to print course packs because while the university produces course packs on a cost recovery basis, the institutional printing contract with the third-party printer includes a commercial element. We also do not apply fair dealing to compilation of works, such as literary anthologies. Instead, we look for original sources of these works and in most cases purchase transactional licenses for them. Indeed, the university applies fair dealing to a very small proportion of course materials used in classrooms today. In a sample of 3,200 learning items, such as book chapters, articles, internet resources used by instructors in our winter 2017 semester, fair dealing was applied to only 250 items, or less than 8%. We most commonly apply fair dealing in instances where a chart, a graphic, or tables from a book or academic journal articles are included in the materials for a lecture. I'd be happy to walk the committee through a detailed example of how fair dealing is applied to a specific course during a question period of today's meeting. At the University of Calgary, we also strongly encourage against introducing any measures to harmonize tariff regimes, impose statutory damages, or introduce mandatory licensing into Canada's copyright regime. Doing so would remove or threaten a university's ability to choose how to manage copyright, compel them to purchase blanket licenses, and result in a university paying twice for the ability to reproduce most of their copyrighted content. This move would be a fundamental change to copyright law and would be studied very closely for all the unintended consequences. Should be studied very closely for all of the unintended consequences that would flow from it, especially the cost implications to public institutions. We understand that in recent government consultations on reforming the Copyright Board of Canada, Access Copyright proposed statutory damages in the range of 3 to 10 times the royalty for even the smallest case of infringement, with no discretion for the courts to vary from this. We also understand that Access Copyright is currently pursuing royalties of a rate of $26 per FTE student for the university sector through rate-setting proceedings at the Copyright Board of Canada. This rate has not yet been confirmed by the board, but if it were, this would mean statutory damages for a university hypothetically in the range of $78 to $260 per FTE student at the institution. That scenario would be difficult for any publicly funded institution. Our opposition to this measure is in line with the University of Calgary's decision to opt out of the Access Copyright interim tariff in September of 2012. This decision to opt out came after considerable consultation with our university community and was driven by significant cost implications stemming from both the increase in the tariff and the limits in the repertoire offered by Access Copyright. The Access Copyright tariff applies only to copying of print materials within their repertoire, and the details of the specific materials included were not sufficiently transparent. As a growing proportion of library materials are digital, the university increasingly found itself paying twice for the same resource, paying the Access Copyright fee for print copies and also paying for the license for digital copies preferred by the university community. This preference and the greater cost effectiveness of digital resources drives a growing proportion of library acquisitions. We have a digital-first policy, and approximately 90% of our acquisitions in 2017-18 in our library were digital, just over $10 million, making print-based collective licenses less useful. When we opted out of the Access Copyright tariff in 2012, It was because we recognized that we could implement institutional copyright policies that would be both more cost-effective and, importantly, responsive to the needs of the University of Calgary community. At the U of C, we take copyright compliance extremely seriously. We educate our faculty, staff, and students about copyright. For example, we recommend all course reading lists be submitting to the Copyright Office to ensure compliance. We have a copyright officer that attends and presents at new faculty orientation sessions and holds regular information sessions for instructors, staff, and students on copyright. In 2017, that copyright officer gave over 22 presentations and workshops to our community. Our learning management system includes reminders about where to seek advice about copyright issues and for the appropriate use of materials. We provide copyright compliance assistance services. We have a copyright office that employs 4 full-time employees, and they processed over 7,800 requests in the winter term of 2017. That same office negotiates transactional license and clearances on behalf of our instructors and professors. In 2012, we became one of the first post-secondary institutions in Canada to adopt a policy on acceptable use of materials protected by copyright that applies to the campus community. This policy includes sanctions for non-compliance. We have a copyright committee that meets quarterly that includes students, administration, and staff. And we've developed a rigorous, we think, and comprehensive approach to manage copyright. In conclusion, we urge the committee to take a balanced, measured, and fair approach to copyright, one that respects the rights of both creators and users. And again, we appreciate the opportunity to appear before you and look forward to questions.
Thank you very much for all of your presentations today. We're going to move right into questions, starting with Mr. Sheehan. You have 7 minutes.
Thank you, Mr. Chair, and thank you to our presenters. It's very informative information you provided. And my background is I was a school board trustee many years ago, and my family, I come from a family of teachers. In fact, my father used to be president of OSTF, and I'm mentioning that because he's in Ottawa today too as well. So I'm going to start out with asking you a question that I've been asking various people across the country and here. And it's about copyright as it relates to Canada's Indigenous people. And Canada's Indigenous people feel that the copyright laws as they exist do not serve their traditional culture and the methods of communicating that. And we've heard from various ones, whether it's the oral tradition and whatnot, and how do we engage? And obviously in your schools you have Indigenous children, you have Indigenous teachers, you have Indigenous trustees, you have Indigenous profs and whatnot. So my question is to you, could you provide some information to this committee about your thoughts on how we could improve copyright as it relates to Canada's Indigenous population? Anyone want to start? It's for all 3 of you.
Give it a start. Knowing that the Indigenous population passes on knowledge traditionally through oral communication makes it difficult to put any kind of copyright on these types of learning environments. When we're looking at a school per se that is addressing the needs of Indigenous children through printed stories and materials, those are made available in classrooms that students would traditionally be able to borrow, such as through libraries or as teacher resources. So when we're talking about building the culture, it goes far beyond just whether or not it's a piece of printed material, because in the experience that I've seen in schools right now, it goes far beyond taking a piece of paper and putting it in the hands of the students. It's more of a lived cultural experience that has a lot more to do with it.
Okay. Cynthia?
Thank you. My experience in this matter is limited, but I can say that with respect to the purchasing of materials, I think that a lot of some of the issues that we're thinking about, if we're talking about printed materials, I think that we could look at some arrangements where materials are printed or published with different parameters around them between the publisher and the creator themselves. And that would be something that the publishing industry would be better informed about than myself. But I know that when creators get their works published, what their compensation is depends greatly on what their contract is with their publisher. So that is one thought that I have. With respect to materials that are not printed, published, but are oral or other things, I know that there are a number of school boards across Canada who participate in a program that brings Indigenous creators into their school to talk to all students about Indigenous art, and they participate in creational art creating days and Indigenous storytelling, I'm sorry. And so by doing that and by promoting artists in the school that come from Indigenous backgrounds, we're making our students more aware of the stories and the art and the culture than they would currently be, and there's often benefits to that for the community.
Drew?
I would say the current Copyright Act does not afford Indigenous people protection for their copyright material. And part of it is the way that those materials are produced. We have just spent a significant time putting together an Indigenous strategy, and I'll give one example. During that strategy, it was apparent that a written document would not tell the story that we were trying to create, and so we wanted to use Indigenous symbols to tell the story. And of course, one of the issues is whether or not you are absconding cultural property if you use those symbols. And so what we did was spent considerable time with the community, and one of our Kainai elders gifted us a series of symbols that we could use and help put those symbols together so that an Indigenous community could pick up our document and essentially read it in their language without having to read the written word.
You asked permission of that?
We did ask permission.
Okay.
And I think any copyright moving forward, any Copyright Act moving forward should include this type of piece within it.
How much time do I have? A couple minutes?
Minute and a half.
Okay. Mandatory tariffs. I don't know if we're going to have to expand on this one. I don't think a minute and a half will be able to get there. But access copyright versus York University, the decision, and the undoubted appeal that's coming. Do you feel that, in particular, the dispute between departments of education across Canada and school boards in Ontario is whether the tariff put in place by the copyright boards are mandatory. So do you believe that tariffs should be mandatory? Yes or no, and why?
I'm happy to start on that if you'd like. I don't think tariffs should be mandatory. I think there are options, and I'll speak from a university perspective, there are options for tariffs and for ways to clear copyright. Right now, Access Copyright is but one collective, and so there are a variety of different ways that you can gain licenses. We had some issues with Access Copyright in terms of transactional licenses, for example. We're not able to obtain them, and it was an all or none approach to licensing, and so we found that we were paying for licenses twice. Furthermore, we also found that their repertoire was not transparent, and so it was difficult to know exactly what we had paid for.
Thank you.
Thank you.
Sure, we can get back to that one. Monsieur Bernier, vous avez 7 minutes.
Merci. Mr. Bernier, you have 7 minutes. Hello, thank you for being here with us today. My question is directed to any and all of you. We heard here before this committee stakeholders, representatives from various organizations. Testing 1, 2, 3. Testing 1, 2, 3. Speaking about the cost of accessing copyrighted material and reasonable fair dealing provisions. So I'd like to ask a question about that. Access Copyright and Copybec have encouraged this committee to not give too much weight to data that would suggest that spending on licensing might in fact be exorbitant. And so for them, for Access Copyright and Copybec, in any digital context, there has to be a distinction made between reproducing and acquiring a pedagogical or teaching tool. Do you make the same distinction? Do you draw a line like that? Because the costs associated are often related to acquiring licenses and in fact not reproducing per se extracts of works. What's your stance on that distinction between acquiring licenses and reproducing works?
Well, I will open by suggesting that Access Canada isn't, Access Copyright isn't in today's classrooms. Today's classrooms are so complex, so to simply say that a blanket license for acquiring material is one way to build a resource to work with the complex needs of students in a classroom is unfounded. In terms of the separation between acquiring information and then being able to disseminate it, there is a very clear distinction on it. I do know that blanket licensing, when you look at the public system across the country, K to 12, they're in various forms. So to have a single way to say this is how we should be accessing information and you either have a license or you don't would be doing a disservice to areas that don't necessarily have the same type of access. We have all sorts of remote areas in the country, so getting access to material is part of it, but then building and using that material to meet the complex needs of a variety of children in a classroom becomes a greater significance to the teachers that are working with children.
So your position on the fair dealing, you said in your testimony that you think that we don't need to change that. The interpretation from the court, it is okay with the criteria to use the material, and it's a fair deal for the authors of these production.
Well, in the interpretation as it's standing, that's been working. And the CTF has gone to great lengths to educate teachers across the country. We use our material such as this for our members. In fact, in my own school, this is hanging right above the copy machine. We have materials going out in publications. I brought 2 of them today from across the country. Articles appear on the use of materials and the gathering of materials and how to deconstruct a purchased piece of material for use within a classroom that does not go outside the copyright laws. So the interpretation as it stands right now is something that we're in favor of.
So you don't think that there's a need for us, a legislator, to change the definition of the use of a fair dealing?
At this point, no.
Okay, and yes, Cynthia?
I would agree that we don't believe that there's a need to change the application of fair dealing as it currently exists in the Copyright Act or the interpretation that was put forward by the Supreme Court of Canada in its ruling. With respect to the issue of acquiring materials, I think it's important to note that school boards are very much aware when they acquire materials about whether or not, particularly digital materials, whether or not those materials include rights to reproduce or not. And one of the things that has been debated at meetings quite extensively is when you're looking at costs of materials, if you think those costs are high, then look at whether or not they include reproduction rights. And if they do, there's a very good reason why that cost might be higher than another resource that does not include reproduction rights, even though the content of the 2 resources may be similar. So boards are very much aware of those 2 issues and the distinction between them, and make choices about what materials they're going to be choosing accordingly.
Okay, and Mrs. Marshall, can you tell us what is the cost for the Calgary University copyright cost, and that the university is paying?
The copyright costs for the university have varied. When we started in 2011, before the proposed tariff, we were paying $2.38 a student with 10 cents a copy. It varied between $10 and $15, I think, when all was said and done at the end of a year. Per FTE student, we have about 30,000 students on our campus, FTEs, so that gives you an idea. You know, to go from 10, we opted out in part because to go from $10 to $15 to $26 or $45 per FTE seemed like a very large jump. And so it cost us, we have to manage a number of, I would say, competing stories all the time at institutions, and we are publicly funded. So one of the things was for us to look very carefully at the use of taxpayers' dollars. We are an institution that has not passed on the cost of copyright to students, believing that that's part of what we do as an institution. So I would say the issues for us in copyright, fair dealing, we did not opt out until the Supreme Court of Canada decision on fair dealing. We thought that this was an absolutely critical part for Canadian society. It's very important for universities to be able to share information and to build on information. So the idea that you could use part of the information available then to take and build on it to create different research is a very important part of what we do at the university, both in research and teaching. So I would strongly support the fair dealing concepts as they currently exist.
Okay, thank you.
Thank you very much. We're going to move to Mr. Cannings. Welcome to our committee. You have up to 7 minutes.
Well, thank you, Mr. Rumi. Thank you, Chair. And as you can gather, I'm not usually on this committee, so I haven't heard the testimony leading up to this. I do have a bit of a background from both sides. I used to work at UBC for many years, and I have written a dozen books or so, and so I get my access copyright check every year. It's not a lot, but it's a nice surprise. But it has been getting a lot smaller lately, so I see that. I also have quite a number of authors living in my writing who've talked to me about this issue. A lot of them write, say, fairly regional books on history and natural history that are used in schools, and these people don't make a lot of money from their writing, but so that access copyright check was actually a good chunk of their annual income. And you know, for me, it didn't really matter that much. But so I see the fairness issues on both sides, and I just want to start with Ms. Andrew. You mentioned that access copyright hadn't been able to show undue economic hardship on authors. I think that's what you were trying to say, and I'm just wondering what the economic hardship on schools and colleges and universities are. We have statements here in the notes. The Winnipeg School Division spending $34,000 a year on copyright materials, $1 per student. Ms. Marshall was talking about something a little bit higher. And I'm just wondering what you think would be fair and not causing hardship to school boards.
I'm going to backtrack just a little bit and clarify my comments about access copyright. What I was saying is that they haven't been able to convince with evidence in courts that that is the case. There's lots of anecdotal evidence that they've come forward with, stories that they've told, and I know that I know from my own experience that what you said about access copyright checks going down is happening. So I'm just, what I'm trying to say is that they haven't been able to demonstrate in a court of law that that evidence exists on to date. What I would also like to say is that with respect to how school boards quantify what they spend on quote-unquote copyright, those costs go beyond what they would spend on a tariff. Because copyright is built into reproduction rights are built into many of the resources that they are currently purchasing, which is similar to what you were saying about paying for something twice. So, with respect to what a school board views as fair, we view the fair dealing guidelines as the most fair way to apply copyright to educational use of works, and with respect to authors that have regional interests in their works. I know that in Manitoba and in the Atlantic provinces, there are arrangements that the provincial government, the provincial Department of Education, and I'm sure this may happen in other provinces, but these are two I'm aware of. There are arrangements that the provincial governments, the Departments of Education have made with local authors to license their materials separately and provide some sort of subsidy or grant so that those materials can be used in the schools outside of their relationship with access copyright. So that is something that a lot of provincial governments are looking at, particularly where resources have a specific interest for a local region.
Okay. I'll just move to Mr. Ramsankar and ask about, you were talking about the movement from print to digital and to online resources, and perhaps all of you mentioned that, but I'm just wondering if you could expand on that. You know, what's the proportion of online versus print material that are used in classrooms, if you know that, and how this might affect authors or producers of that material, how that is factored into your purchases, or whether teachers are going online and looking for free material specifically because it's free.
Well, I don't have the exact figure in terms of the percentage of online versus print material at my fingertips in terms of the uses in classrooms. But I would suggest that teachers are subject to their own personal purchasing power or that of a school. Teachers don't, on an individual basis, purchase textbooks, for example. They would be purchasing individual materials that they would be using for either developing a curriculum or building a unit for the students that they have. Pending the complexity of the classroom, may require different types of access to material. The concern that teachers are looking at right now are what are they subject to in terms of the use of material that is purchased and that they've already brought into their classroom to augment the curriculum development. What we're talking about right now through fair dealing is it allows excerpts to be used by teachers. The notion, for example, that whole textbooks are being printed, I can say for a fact that the budgets in a school or teachers' individual purchasing power to be able to photocopy, that's unheard of. And in fact, many teachers across the country are subject to specific accounts that limit the amount of photocopying they're allowed to do. And when you're talking about your own developed material and the materials that you would be using in your classroom, going out necessarily and printing something that has copyright applied to it is wasteful, and it's not used in that sense. Digital material, as it's brought into the classroom, it's cited for students to be aware that when they're using it in their own research, teachers do talk about the development of copyright, citing and giving credit for material and thoughts that are not their own. And that's the use generally in the K-12 classrooms.
Thank you very much. We're going to move to Ms. Ng. You have 7 minutes.
Thank you so much, and thank you everyone for coming in to speak to us on this study. It's an important study, and I'm going to start with with the teachers, and picking up a little bit on what Mr. Canning was talking about. If you can just sort of talk to us. And I think you already touched on that, but just around, a set of policies that exist for teachers so that there is the compliance to fair dealings, because we certainly have heard from publishers, we've heard from authors about, about an excess use by teachers. So if you can talk to us about kind of, I know that you've got sort of a booklet, and I think that booklet is out there to all of your teachers, but just expand on that a little bit, and maybe the school boards could talk to us about that as well to help just clarify for us an understanding about the policy and the rules that teachers actually work within to comply with fair dealing.
Well, we went to work right after, right after the Supreme Court ruling. And that was the production here with our education partners. There were, during that time, on professional development opportunities in the different provinces put on by our member organizations speaking directly to copyright. The article that I cited just recently, this is in March, April 2018. There's still an article talking about fair dealing, talking about copyright. So it's alive and well with our professionals as they're coming in. As our population, the demographics of teaching overturns, we continually are vigilant to make sure that teachers understand that what they're doing in terms of the use of copyrighted material falls within compliance of the latest definition. So in answer to how do we continue to do it, the rules are laid out. Most of the evidence that I've heard in terms of teachers going outside compliant rules is anecdotal, and I would consider those very much one-off, and I don't say that tongue-in-cheek. Individuals that go outside opportunities or use, they're usually cited. Either the principal or the board itself will make note of that. The teachers are made aware of it, and material is either withdrawn or taken back. But these are very much one-offs, and I can't emphasize that enough. This is not a mass happening across the country.
And school boards, what kind of, sort of policies or rules are in place to help guide the compliance in the schools?
Well, I'm going to sort of split your question into two. There's the education aspect of what we do to educate our staffs, and Mark has spoken very eloquently about it. It happens at multiple levels. So we all use consistent materials. You'll see that we have the same book. We use the same fair dealing guidelines. There are posters that are produced by provincial governments through their involvement in the CMEC Copyright Consortium that go out to every school. Every year in September, this material is redistributed through the school provincial associations or the provincial departments down to the boards and through the boards to the schools. So this happens on an annual basis. So all the materials are shared on a regular basis, and then they're also shared through other means, like through their unions or through education articles and things like that. So there's lots of opportunity for this information to get shared with school board staff, not just teaching staff, but all staff. And on the side of compliance, it is the school board's responsibility to ensure that its staff is following all of its policies. School boards have a number of policies, and any non-compliance that would be identified with copyright would be dealt with through a school board's process that it follows depending on which province it's in, because it's going to vary province to province. It may even vary board to board, which process it follows to communicate with the teacher about what they've done wrong. And frequently, when things are brought to a board's attention about non-compliance, it's more a matter of, oh, I just didn't know that, than it is a matter of, oh, well, I didn't care. It's a matter of ensuring that that person is educated about what they're supposed to do, and then very rarely, in fact, I've yet to been made aware of a situation where a reoccurrence of that non-compliance has occurred. Okay. So from that perspective, I think that school boards are doing their due diligence as employers to ensure that their employees are following all of their policies and laws are outlined in that.
Okay. Thank you both. We've certainly heard from, from everyone, I think, that will say to us that they want to ensure that that the works of creators are respected, and that and that their and that compensation for them is is fair, and and so forth. And yet, and while at the same time, as I said earlier, we've heard from publishers and authors who've clearly indicated an impact. So can you so maybe this is just for our understanding, can you tell us sort of from a school board perspective around spending then? Did you at one time, like the universities, like the post-secondary institutions, pay the tariff, and then now just because because teaching methods have changed, materials are available in many different formats, so rather than sort of a tariff method of paying for the material, it's the transition to paying for transactional licenses. And can talk to us about, I think it's two questions: has your spending changed, and is and what's sort of the before and the present now?
I would suggest our spending hasn't changed. The tariff amount that
Do
we
you have
pay.
data on that at all? I mean, do the
Not
does the school board-
nationally, no.
No, okay.
Education is a provincial jurisdiction, and so it's very difficult to get national information on how spending occurs. It's actually difficult to even get it at a provincial level because not all provinces have the same budgeting structure. So what might count as learning resources in one province doesn't count as learning resources in another, that sort of thing.
I think I'm almost out of time, so could you try to
Okay,
get at
yeah.
that?
All right. So now I've completely lost track of my mind. So with respect to spending, I would suggest it hasn't changed.
Okay.
That what's changed is what we're buying, and we're buying more of the digital-based resources and greater variety of materials. What was the other half of the question?
That's it. I
That's
think
it?
I'm out of time.
That's good.
Because the
That's
chair
all,
is
that's
gonna
all we got time
cut
for.
us off.
Mr. Lloyd, you have 5 minutes.
Thank you, Mr. Chair. Thank you. Appreciate everyone coming out and your testimony today. I'm just interested, Miss Andrew, what do you have any idea? It's kind of related to the previous question. What are the current costs overall for copyright for your stakeholders, and can you break that down on a per student cost on average across Canada?
I can't, and I wish I could, because I would love to be able to answer that question. I think that it would do me a really, I think it would serve me well to be able to answer that question.
Well, so the evidence that we have been provided, the Winnipeg School Division told us about $1 per student is what they pay. So for 34,000 students, they said their cost is about $34,000. And then the information that was provided to us by Access Copyright says that the tariff has been set at $2.41 per student, per K-12 student. However, the majority of schools outside of Quebec are no longer paying any tariffs. And so the cost would be $0 for collective licenses. Would you say that's correct?
For collective licenses, yes.
Okay.
For licensing, I would suggest no. I think that we do pay for licensing, and I do think we pay for reproductive rights.
And who's being paid for that?
Who's being paid?
Yeah.
In some cases, it's a distributor of an online database. It is the creator of repositories. Provincial governments, when they do material portals, will often pre-clear all of the materials that go on those portals, and where payment is required, will make that payment. This happens at board levels, at provincial levels.
But previous to 2012, you were paying a collective license. And after 2012, you're no longer paying a collective license. And so would you say there's any correlation in the loss of revenue for Access Copyright?
I think that the loss in revenue for Access Copyright can be attributed to many different types of changes.
But if you're not paying them, then that's a lost revenue for them, correct? Like, it seems kind of obvious.
I think that if we were paying them, they would have that revenue, yes. And
Okay.
who wouldn't have it would be the same creators, only in a different area. They wouldn't be getting it through these other areas.
So it seems like there's a direct correlation between the K-12s not paying the collective licensing and then the authors not receiving the royalties for their costs. So authors are hurting because K-12s aren't paying for their copyright, correct?
I would suggest that most of the purchasing that happened in K-12 sections were through education publishers, and very little of it went to individual authors. But yes, there would be some impact.
Okay. Well, thank you. I appreciate that. My next line of questioning is for Mr. Ramsankar. Thank you for your testimony. Would you say that previous to 2012 that teachers had a hard time accessing copyrighted works to give to their students, and has there been a significant change after 2012 for the on-the-ground teacher?
The on-the-ground teacher, when you're speaking of access to copyrighted material, has to be defined. If you're talking about textbooks and textbook material, that's provided by the employer. Mm-hmm. The individual teacher that is using resources in the classroom would be using material that would be in the form of articles or individual novels and that sort of thing that a school may produce.
Were they having trouble before 2012 accessing those resources that you just mentioned?
I want to be careful in how I say this because I've been, for the bulk of my career, focusing on resourcing schools and classrooms. Now that takes on many different forms. It takes on forms of time and material, as well as the ability to be able to produce materials on their own for classrooms.
Was there a big difficulty in accessing files before 2012?
Teachers did not have issues accessing materials that were provided by the employer.
Okay, thank you, I appreciate that. And then my final 45 seconds for Ms. Marshall. I really appreciate your testimony. I'm going to rant a little bit here because a lot of universities, have not been able to provide us with the data. And you said, you have 3,200 works that you've used, 250 have been used for fair dealing, and really appreciate receiving that breakdown because that's the kind of accountability that I think a lot of the stakeholders just want to see from the universities so that we can dispel the confusion around this issue. And I'm hoping you can quickly comment on, do you think that the retroactivity of the Copyright Board, like your fear of having to pay $26 going years back, that's such a huge fear. Would you say that it'd be better for the Copyright Board to be more forward-looking, to set rates over the next 5 years so that you can have predictability and stability in your funding and what you need to pay? So you would say, yes, that's something you'd like to do.
Yes, I think there's a fear across the country in post-secondary institutions about any retroactivity, particularly when we think we've been managing copyright in an appropriate fashion.
Thank you. I appreciate that.
Thank you very much. We're going to move to Mr. Jahari. You have 5 minutes, please.
Thank you, Chair. Thank you to all the witnesses. Mr. Ramsankar, I'm going to start with you. In your opening remarks, you made a comment, and I'm not quoting you, but this is my understanding of what you made a comment about, that the need in the classroom has changed. And the fact that access copyright is not in the classroom and they don't understand the change of that need and the complexity of today's need to be able to help the children in the class, but K to 12. Can you expand on that one and explain to me why access copyright doesn't understand that and what has it changed? Because until last year I had a K to 12, and he was still using textbooks. So,
well, the variety of material that is used is, in a teacher's view, needs to be accessible. However, the use and dissemination of that will change depending on the nature of the students in the classroom. When I talk about the change in the classroom, I'm talking about the demographics within the classroom, children that have needs that go beyond the norm. So teachers need to have the flexibility to be able to alter material, work with material to meet the individual needs of a child. For example, if you have a student that's in grade 3 who's reading at a grade 3 level, there's a certain approach and strategies that teachers will be able to use. If the same classroom has students that are reading at a grade 1 level, then the same material, because it's part of the curriculum, has to be disseminated differently, has to be broken down, has to be created in such a way that the child at that level will be able to understand the concepts being taught. So when I talk about understanding what it's like to be in the classroom, the idea of just doing blanket material, blanket licenses because it's the same for all because you're purchasing the material, to me, what I'm suggesting is that doesn't necessarily work in all scenarios because you're not able to take one type of material and then just apply it to today's classroom.
Yeah, thank you. Next, Ms. Andrews, you said that Access Copyright is using anecdotal numbers, and they really haven't been able to clearly demonstrate in the court of law that there is actually infringement in reproduction. They were here on Tuesday and they shared some numbers with us. 600 million pages are copied for free. That's the claim they made. And they said 89%, they've had 89% reduction in their royalty. Can you expand? Where do you think those numbers might be coming from? And
I think I would like to know as much as you where that $600 million or 600 million copy figure comes from, quite frankly. I'm not sure where it came from, and I'm not sure if it's K-12 only or if it includes post-secondary copies as well. But if it's 600 million copies per year, and if there's 5 million students, that's 120 copies per student per year. And that makes how much per month? 10 months. So that makes 6 copies per student per month. I'm getting that wrong. My math is not my strong suit. But anyway, it makes for a low enough number that, to me, this does not demonstrate industrial copying, if you will, or widespread copying. It means that teachers are copying short excerpts, like the Supreme Court said they were. And
so before they were not, because they said their Access Copyright, they said their aggregate revenue went down after 2012. Actually, 2013, from 40 million to 2017, which is somewhat below 10 million. So is that attributed to the complexity? One might be the complexity of the way that we are providing material. I think, Ms. Marshall, you're trying to jump in, but anybody can answer that question.
I'd love to answer that question. There's no question that Access Copyright revenue would have gone down because a number of groups opted out of the collective. They were no longer paying their fees. So, of course, their revenue is going to go down.
But is that fair?
Well, here's the choice you have as an administrator of a university. You can choose to belong to that collective and recognize that on multiple occasions you pay twice, or you can choose to manage it your own way and clear copyright in a different way. It's not that we are not clearing copyright, we're just deciding to do it in a different way. We're deciding to purchase licenses in a different way. So there's no question there's a tie to a decision where people decided to opt out of a collective. I'm surprised, to be honest, that Access Copyright has been able to survive as long as they did with the number of universities that opted out of their licenses.
I'm over by 45 seconds, so I thank the chair.
That's okay. We enjoyed your answer. We're going to move on to Mr. Generou. You have 5 minutes.
Perfect. Thank you, Mr. Chair. And thank you for being here. Ms. Marshall and Mr. Ramsanker are both coming from Alberta. I appreciate seeing you both again, and not to leave you out, Ms. Andrew, coming from, I guess, the big city of Toronto. So
I actually live in Brantford.
oh, do you? Excellent. Cleared the record. You're living in Ottawa. Oh my goodness. Okay. Anyways, I guess time's done now. I do want to just quickly ask you, Ms. Marshall, do you have any relationship at all with Access Copyright now?
No.
Even through a distributor of any sort?
We opted out of their licenses, and we have gone back on occasion to ask for a transactional license in what we think for something that is in their repertoire. And they have used an all or none approach. If you're not in the license, in the collective, you're not allowed to do a transactional license. And interestingly, what that has resulted in us going to different copyright collectives, like American Creative Concepts, to purchase transactional licenses.
When was the last time that you would have contacted Access Copyright?
It would have been probably 13, 14.
Okay.
Right? Once we opted out in September of 2012, we went back on occasion. And we were surprised at what we found out as we opted out, how many licenses we had paid for twice, because we weren't sure that that license was included in the repertoire that we had purchased.
Right. Okay. Interesting. Do you want to, Mr. Ramsenker, question you a little bit? We heard from Ms. Marshall about the potential of retroactive payments that could happen if the York decision maintains its where it is right now. It was voted against the fair dealing guidelines. It's now under appeal. We know that, but there is a potential that it stays the same. On your website, directs visitors who have questions about copyright to the fair dealing guidelines that were produced by one of our previous witnesses. And I think you brought the booklet there with you, the Council of Ministers of Education of Canada. So I take from that the CTF is obviously endorsing the guidelines, even though they were essentially thrown out in the York decision, which again is under appeal. Do you have any? Does CTF have any plans, considerations in place if that decision remains same to continue to pay for that copyright material?
At this point, the York decision is in the courts, and it's viewed as an outlier. So to make speculation or trying to suggest decisions that we would be going at this point, I think would be premature. And so on that basis, to be able to say we would go in one direction or the other is too soon. York was an outlier, and right now the courts are dealing with them.
Okay. May I give you the opportunity to, if you wish, Ms. Andrew, we've had it addressed by Ms. Marshall and Mr. Ramsenker, on any plans of if, again, the York decision maintains the way it was decided, are there any plans in place to have to pay retroactively in your organization?
I'm going to repeat the sentiment that Mark has put forward. At this point, we do not have any plan in place. All of those decisions will be made once a final decision on the court case has been determined. And again, we do believe it's an outlier that previous court cases found in favor of users, and so we're hopeful.
Okay. All right. Good.
You're very effective with your time. Thank you very much. We're going to move to Mr. Graham. You have 5 minutes.
Thank you. I'm going to start with Ms. Marshall. You mentioned earlier that 90% of your spending in 2017-18 was on digital material. Can you compare that over to 5 years ago, 10 years ago, obviously 20 years ago there wasn't very much. Give us a sense of that trend line.
Yeah, I think this is a really important question, actually, because there have been many stories that tie the loss of revenue to authors to fair dealing. And in fact, I would tie that loss of revenue to the digital revolution. We actually have a digital library. We do not have books in our library, or very many books in our library. So probably when we started our digital library opened in 2011, I think we were close at that time to probably 30% digital, and we're now up to 90% in terms of costs in a year.
So the change has been very rapid.
Yep.
Do you see a significant, and this is to all of you, do you see a significant difference in behavior between educators of different generations, I'll put it that way, between who uses digital and who uses traditional paper materials? And as the new generation of educators are coming up, are they just not looking at paper?
I'll maybe just give a quick answer. At the universities right now, we are dealing with students who are digital natives. So you ignore digital content at your own risk when you're a professor.
That's fair. You mentioned earlier there's sanctions for non-compliance in your processes.
Yeah.
How do those work? What are the sanctions?
So,
and if you want to use this opportunity to do your detailed example that you mentioned in your opening, it'd be a good chance to do that.
Yeah. Well, I have our policy here. I'll say the sanctions for people who are out of step with our policy. And I'll read them directly. For employees and postdoctoral fellows who use material protected by copyright in violation of this policy may be subject to formal disciplinary action up to and including dismissal.
Has that happened?
Very, very serious. It has not happened, but we certainly have had sanctions before. In students' cases, students who use material protected by copyright in violations of this policy may be disciplined under the non-academic misconduct policy, which allows for expulsion from the university. So we, as I said at the beginning, we take this very seriously. We take an educative approach in the first instance. In the first offense, we say, here are the things you must be aware of. When we find something that has happened, we go back and ensure that authors are appropriately provided with the dollars that they should have been in the first place. But I mean, I'm happy to give you an example of fair dealing, or if ebooks versus the print copy costs, if you'd like.
Sure.
Sure. Which one would you like?
Why stop at one?
Okay, let's go ebook versus print costs. So because we're a digital library, ebooks are purchased whenever possible, and when available, we look at the cost of a multi-user ebook. It's often less than a transactional licensing fee, and it doesn't limit access to students only enrolled in one course. So for example, licensing of 2 chapters of the book, Oil, A Beginner's Guide, 2008. This is an important book in Alberta right now, by Václav Smil, for a class of 410 students, would cost the library $2,463 in US currency. In contrast, the cost of an unlimited license for 3 ebook versions would be $29.90 through eBook Central, and the book would be available to all library users. So that's, in many cases, why we've gone digital. I would say similarly, the cost of licensing 2 chapters from the book Negotiating a Vacant Lot, Studying the Visual in Canada, by Linda Jessup, for a class of 60 students would be 414 Canadian, while the cost of an unlimited license on eBook Central would be $150 US. So there is a tremendous difference in these costs. We use those, and we also are dealing with the needs of our students who want the material digitally. They prefer to do that. Our professors are very conscious of ensuring that students are getting materials in a way that they're going to use them.
Appreciate that. Do I still have time? Yeah, so another question I'd go to for all of you is, the Copyright Modernization Act 5 years ago was famous for bringing in TPM exemptions to copyright. I'm wondering how, if at all, that affects you, the technological protection measures. So if you have a digital lock, that fair dealing no longer applies.
Well, the teachers that we're looking at, we don't have the ability to unlock. So it's you're using as a one-time. You're using one piece of material. It's not like you can unlock it and then go through it. That's the experience that I've had with the teachers in our systems.
So is there a lot of material that you're just not accessing as a result of that?
That is the result. Teachers, by and large, don't have time to be able to start trying to unlock things and figure out how to use one specific material. If it's not accessible, they're moving on.
I think this is a really important area for this committee to pay attention to.
That's why I bring it up.
Yeah, digital locks. Let me give you an example. We purchased not long ago a variety of CDs. And this is how rapidly the technology changes. Now, of course, people want to stream the material live in their classrooms. If we want to do that, we have to pay for a new license for exactly the same material. So it's interesting. I think, while the digital revolution has been absolutely spectacular in terms of teaching and research, this is a new age, and I think the copyright laws have to be updated to help us manage.
Out of time, but if I have a chance later, I'd like to come back. Thank you.
Thank you very much. We're going to move to Mr. Cannings. You got 2 minutes.
Well, I'll just go straight to Ms. Marshall, and I guess what I would ask is there, you've mentioned other collectives that you're part of. Is there a place for a national collective like Access Copyright? And if there is, how should it be designed?
You know, that's a fantastic question. One of the values I think we hold near and dear as a country is choice. And it seems odd to me that we would force institutions like ours to make one choice around something that is really important from an educational perspective. And we have to balance rights of creators and users. So I'll leave it at that. I would hate to be forced into something when you know there's alternatives that might be better for particular institutions, and I don't think it's fair to say one size fits all.
So is there no way that a new access copyright could be designed so that there was that flexibility?
It's possible, but I think you'd have to look at that very, very carefully, and there'd probably be sliding scales of costs depending on what people would want to do. I think access copyright took some very draconian steps to try to protect users, and they associated decreased author fees with a number of things that actually were fallacious. I would say decreased author fees are more associated with the digital revolution than with fair dealing, for example.
Either of you want to comment quickly on that?
Well, I just to echo Ms. Marshall's comments. The use of and the onset of digital material has had a dramatic effect on the use of print material in that sense. And to try and draw a direct correlation between print material and the non-use of access copyright as opposed to how the impact of the digital age has had isn't doing a service to the people that are using the materials at this point.
I would like to add to that the fact that we cannot purchase transactional licensing from access copyright. I get numerous requests from school boards that say, I'd like to copy more than what the fair dealing guidelines allow. How do I do this? And I say, my answer has to be, you approach the author direct or publisher, copyright owner directly, and if they say no, then you do not copy. Your choice is get permission and payment where it's required, and if you cannot get permission and payment where it's required, you do not use that material, you find other material. And 9 times out of 10, people have had to find other material because they cannot acquire a transactional license.
Thank you very much. Mr. Brattina, you have 5 minutes.
Thanks. So I'm going to try to outdo my colleague, Mr. Sheehan. I married a teacher. Her brother was a teacher. He married a teacher. Their 2 kids are teachers. One married a teacher and one married an EA. So I ran for federal politics so that for 6 months of the year, I don't have to listen to teachers' conversations. And my son has his MA in library science, and he's now a Mountie in northern BC. So I think we're... But the reason I mention that is all of those dinner table conversations, I never heard this come up. The only thing I ever heard really was whether on a snow day you could play the movie Oliver, for the kids who showed up. So how pervasive, or you held up, Mr. Ramsankar, the piece that you have hanging, you both have it. So is that how it's circulated among the teachers?
Go ahead.
Well, we work with our member organizations to see that the material is available. It is in schools. I say this is hanging in the photocopier room, but we go beyond just the material that's contained here with the rules. And I cited the example. This, for example, as I said, this is March, April 2018 out of Newfoundland. The articles in here talk about the copyright issue, the use, whether or not teachers are complying. To be honest with you, when you're talking about your dinner conversations around the table, talking about education, teachers that I sit with don't sit around the dinner table and talk about copyright. What they talk about is, how are we strategizing to work with student X, or what happened in the classroom? When copyright comes up is when you have parameters set around you to access material or to help children access material. That's when copyright comes up. The title of our book is right there, Copyright Matters. So there is respect when you're talking about developing materials to use in your classrooms. And in fact, I will take it a step further. As I said, I speak for K to 12. When we're teaching about ethical research and writing papers, it goes right back to simple things like plagiarism. giving people credit for what they have written and what they do, and make sure that they are cited correctly. And as teachers, we need to model that. So simply making the statement that a teacher would blanket copy a hardcover or a piece of paper and then disseminate that out on one hand and then say, oh, by the way, you have an ethical responsibility. That doesn't fit. And that's why I say most of the anecdotal evidence are one-offs or people that have gone outside. And when cited about it, it's not automatically that an employer or a principal will take a punitive measure on an individual. It's a teachable moment. You talk about copyright and how it goes. You make the corrective measure and you move on. Because that is what we're talking about in terms of the use of materials in classrooms. So
the digital topic is common at almost every conversation now, by the way. Who monitors compliance, or how is it monitored?
It's firstly, the person who would monitor it would be the principal, because that is the person who is responsible for distributing. Once they get it from the board, it's their responsibility to distribute the material to the staff and to talk in a staff meeting. Every principal across Canada is asked to speak in a staff meeting about copyright at the beginning of every school year. So that is the first step. Every board is asked to have a staff member in their administrative office who is familiar with copyright, so that when principals have questions that go outside their original knowledge base, they have someone to turn to. So there is someone at the board level, and if there is someone at the board, if the question goes beyond the person at the board level, there is a list that's available. I don't think it's actually in this book. It isn't. There's a website that was created by the people who worked to create these materials called copyrightdecisiontool.ca. I encourage you all to go and take a look at it. That particular website has all of these materials on it for instant download. It also contains a list of provincial contacts. So if your question goes outside of, like, you know, what can I copy under the guidelines, and it's more complicated than that, there is a list there of contacts at the provincial level for you to reach out to and get the answer to your question.
That's very helpful. Thanks very much.
Thank you very much. And we're going to go to Mr. Lloyd. You have 3 minutes.
Sure. Well, thank you. This next line of questioning for you again, Ms. Andrew. My colleague, Mr. Johari, kind of had some incorrect information. It wasn't 600 million pages for the K-12 sector. We actually have evidence from the Copyright Board's decision in February 19th, 2016, that there were 380 million pages copied each year of published works from Access Copyright's repertoire. And this was done by the K-12s from 2010 to 2015. And the Copyright Board ruled in 2016 that out of that 380 million pages, 150 million pages were illegally copied by the K-12s. And so it
was that those copies were compensable.
Yes,
Yes.
They needed to be compensated for. But has the school boards compensated for those in the wake of the decision by the Copyright Board?
We have not, because Access Copyright does not offer us transactional licensing.
But it's really up, like the Copyright Board has made the decision that you copied 150 million pages without compensating, but you haven't compensated the board, so are you?
If you look at the breakdown of what those pages are, those pages come largely from materials that are considered to be consumable documentations. Consumable documents that were sold for one-time purposes. So what we did in response to that was we sent out a prohibition to all of our school boards across Canada through the Ministries of Education and through CSBA and through the unions that consumables are no longer allowed to be copied. They are illegal and therefore shall not be copied. There is a poster.
And that's very important, and I think they would appreciate that, and the authors would appreciate that. But what about the pages that were printed before that time? So I know it's going forward, but has it been compensated for going back? Like, have you?
Well, we paid a
complied with the
tariff going
Copyright
back.
Board? So you paid the tariff going back previous to the 2016 decision.
We paid the tariff for 2010, 2011, and 2012.
But these numbers go from 2012 to 2015 as well, so you're not paying the tariffs for that period?
That is correct. We are not. Though that data, by the way, was found in a survey that was conducted in our schools in 2006. So it's more than 10 years old. I would suggest to you that copying habits from that time to now are substantively different. The Copyright Board itself did say in that very same ruling that that data is outdated and beyond its useful purpose. I would suggest that copying from consumables would look very different if we conducted a survey today.
No, I'm not familiar with consumables. Can you kind of describe them briefly?
When you go to Costco and there is, math for grade 2, and it's colorful and it's got pictures and you fill in the little blanks and it's intended for you to take home to your child and have them fill it in. There's similar kinds of materials that are created by publishers for educators, and they're intended for one-time use. Those kinds of copies are not.
So they're distinct from like a book, for example?
They're distinct from a book.
Textbook.
They're also distinct from a resource that's intended to be copied, which we call a reproducible, where a creator will give a teacher's guide that has blank pages in it, and it's and intended to be copied.
Yeah, I appreciate that explanation. Thank you. And my final question for Ms. Marshall, can you comment on, because we've heard from many different universities, and there seems to be, although many of them had joined York in this case, there seems to be a difference in policies at these universities. For example, I believe Guelph University actually continues to pay for a certain level of collective licensing. Is there a disagreement amongst the universities about, or is there a monolithic agreement over fair dealing and copyright and licensing?
I think there's general agreement on fair dealing. I think there's various points of concerns, and part of it is related to size of university in how you manage copyright and whether you can be effective. And so, for example, some universities opted out in 2012, and when there was a model license developed, opted back in because they thought there was better protection for doing that.
So there are some universities that have chosen to opt back into the process.
Yes, absolutely.
And something that I thought was interesting was, it seemed like Access Copyright was asking for an exorbitant $45 amount initially, but that it was negotiated down to the $26 amount.
Right.
It seems to me like that's almost half of the amount, and that might very well be the best number, but isn't there an opportunity for universities for more back and forth to get a better number for the universities?
I hope there would be, but for example, if we were paying in the $10 to $15 range with a $2.38 plus a 10-cent per page fee, going up to 26 and then 45 to me seemed ridiculous. So if I know our students, when we're doing our costs, if our students are $10 to $15 a student, why would I pay 26? And so that's the concern for me. Do we have the numbers the right way? And why did we jump to 26? Part of that, I think, Access Copyright, rightly so, wants to protect creators. But part of the issue that we have not discussed at all here is the publishing industry. And we don't control, when one of our professors, for example, writes a textbook, we don't control the contract with the publishers, but the publishers are having record profits while the authors are getting less money. There is something wrong. And so we balance not only part of being part of a collective, and we try to be parts of collectives in response to an earlier question, both for copyright. I mean, all those opt-out institutions got together. We shared information. We talked about how we would clear copyright. We shared best practices and how we did that. That is I would argue is a collective in and of itself. We also joined together in many ways to purchase product from publishers to see that if we're part of a collective, can we get a better deal? And we've had to come out of those as well because we're finding the publishers are just ratcheting up, and there's a monopoly with 5 or 6 companies intellectually when we talk about material, academic material, that makes it very difficult. This is why you see the rise of open educational resources and open access materials that also have had an impact in this area.
I appreciate that. Thank you.
Thank you. And the publishers are actually coming in next week. So, for the final 3 minutes, Mr. Graham, you have the final
I
take
hope
of
my
the day.
3 minutes are about the same as Dane's 3 minutes.
No, we're tight 3 minutes.
All right. First question. You've, on a couple of occasions, Mr. Ramscar and Ms. Andrew, you've held up a book. This meeting is not recorded on camera, or is it? So I want to make sure that we have that on the record. It's called Copyright Matters, right? Yes, it is. Is that in itself in the Access Copyright Repertoire?
No.
No, okay. Is that something we could get a copy of? I think what it says could be quite informative to our study.
I can leave you my copy. I believe it was distributed by CMEC last week when
Okay,
they
I
were
wasn't here last week, so.
But it's also available for free download from copyrightdecisiontool.ca.
Excellent. I'll take a look at that. Thank you. Now, I want to come back to my last question for the day to Ms. Marshall. In her earlier comments, you discussed a lot of, you discussed at length the lack of transparency from Access Copyright.
Yes.
What did you go into more detail? Like you mentioned that you're double paying for the same material. Can you expand on that? How do we even know?
Yeah, there's two ways universities double pay. The first one is if we purchase a license in print material and then we want it in digital, we have to pay for it again, right? And Access Copyright doesn't deal very much in digital materials, so that creates an issue. The second way is related to research that universities produce. So research on campuses is typically federally or provincially funded through the public purse, right? For the vast majority of it. Universities take that money, researchers do research, then they are required by tri-councils, which we really agree with this policy, to publish their material. We're trying to go more open access. But in order for researchers to get promoted, merit on an annual basis, they want to publish in the best journals. They pay to publish, right? They provide a publishing fee to the publishers, and then the universities in turn pay a license to read that same material. It's a good racket.
All right, well, I appreciate that. Thank you very much for coming. Thanks. Mr. Chair? Your mic's on.
I thought you said you wanted 3 minutes.
3.5.
That's 2 minutes.
All right, I can keep going if you'd like.
No, we're good. Mr. Jahari, you have something to say?
Comment I want to make. In response to my colleague, Mr. Lloyd, I wanted to make sure that the records are set clear. The number of 600 million pages that I referred to was actually goes back to and I'm going to read quote from the Blues Note. This was a response by Ms. Levy, and this was the response to the question that Mr. Massey raised. And now I'm going to read Ms. Levy's comment. When you use all the data on a conservative end, you will end up with 600 million pages that are copied but not paid for. And the 600 million that I made a comment for was the aggregate, and you referred to the 385 million as it was related to the K-12. But my 600 million basically is about everything.
Yeah, and I'm
no,
not defining that.
just wanted to make sure that.
Oh, yeah,
the
not saying you were
clarification
wrong,
is
just
that.
different groups.
Thank you.
We're still one big happy family.
Absolutely.
And we will remain that.
On that note, God, I love this committee. I would like to thank our three panelists today. Every time we think we have it all, you give us more. So we look forward to continue this process. I want to thank you all coming today, and we are effectively adjourned.